What's up, Colorado Realtors? I'm Scott Peterson, and welcome back for another episode of Legal Bites. So you got a whole bunch of forms this year, a bunch of forms updates this year. I think I counted maybe 14 or 15. You've got 4 deeds, bargain and sale, general, special warranty, quitclaim deeds. You've got 2 bills of sale. As I've expressed to you in my holiday edition, not that you would take advice from some guy that was dressed like the abominable snowman, I would avoid those. Don't use those 4 deeds. Don't use those 2 bills of sale. Let the title company do it and keep yourself out of that deed preparation or bill of sale preparation loop, right? So that's 6 of those forms, and you got some revisions to the broker disclosures to buyer, seller, landlord, and tenant. Those are 4 forms that you got, and some minor sort of updates in terms of brokerage relationships and specifically related to acting as a transaction broker and treating the other party as a customer. The exclusive right agreements all got updated. Buy, sell, landlord, and tenant all had some substantive updates, and if you haven't been checking those out, hopefully you've been using them already multiple times so far in 2020, but if you haven't checked those out, make sure you check out the red lines that are on the Division of Real Estate's website and maybe take a contracts class to get some education on the substantive changes there. And I think the amend extend to the brokerage agreement had some sort of conforming changes I would describe, and probably another 1 or 2. Well, you got a new form though, one brand new form that previously didn't exist in the annals of the Colorado Real Estate Commission promulgated contracts, and it's the agreement to revive a contract. All right, so I'm going to give you try and simplify this for you as much as I can. It's a relatively simple document. It's just a 1-page document, and you know these people are perplexed. I think that's very funny that they're so confused. It doesn't need to be confusing. I feel like it filled a vacancy in our state promulgated contracts. Here's a situation that I would get very frequently on the hotline in years past related to the contract. I think there's 8 or 9, I forget now, specific individual places in the contract where we have what I describe as passive termination of the contract. And what I'm essentially referring to, the most common one that we end up having invoked, and the best example probably to use, is related to inspection. So a buyer gives a seller an inspection objection prior to the inspection objection deadline, and then they don't either sign an inspection resolution, or the buyer doesn't withdraw the inspection objection prior to the resolution deadline. If one of those 2 things doesn't occur, then the contract terminates all by itself passively. And that happens in, like I say, I think 7 or 8 other spots in the contract. I forget the exact number, but that's passive termination. And so I would very commonly get calls at the morning after, midnight on the day before the resolution deadline, and either the buyer's broker or the seller's broker would call and say, well, our contract died last night. We gave an inspection objection, but we didn't want it to die. We wanted it to stay alive, but maybe we were having a midnight showdown to see if the seller was actually going to sign that resolution, and maybe somebody fell asleep or somebody was out of town, they couldn't sign. Whatever occurred, contract dies. All right? And then the next question I would get from them is, can we just do an amend extend to revive the contract? And some of you maybe have been armed with some language from maybe your law firms or others that have used the amend extend to properly, in some ways, revive a contract. But you got to remember that our amend extend to the contract, it contemplates a contract that exists. And if the contract terminates at midnight before or 2 days before or whenever it is, then it doesn't exist anymore. And I would argue you don't have anything to amend. And so there wasn't a great tool to properly revive a contract that had died, whether the parties intended it to or not. Well, now you have that document. It's a simple, like I say, agreement to revive the contract to the extent that the parties, after a buy-sell contract has been terminated, has died passively, or even otherwise, the parties can now agree to sign this 1-page revival document, and there's a small place where they could make some additional amendments to that and essentially revive the contract, bring it back to life. Because the problem with, like I say, doing the amend extend is I never felt like that was contractually really appropriate. And then the other solution then would be to do a brand new contract and maybe knock out all of the previous dates to that point in the contract and just pick up from the point in terms of contingencies and move forward. But oftentimes when the parties would do that and sign a new contract, just moving forward from from whatever date made the most sense. The buyer then, if they were getting a loan, would send that new contract to the lender, and the lender would say, no, this doesn't work. We got to open up a new file, right? This is a new contract. We got to open up a new file, and then everybody's sort of back to square one from an underwriting standpoint. So that was the other alternative, and it wasn't a great one. But now you've got what I think is a pretty fantastic and pretty simple alternative. When not to use the agreement to revive a contract. I think that the safest sort of teaching advice around this is it is not meant to revive a contract that died 3 years ago. I could make an argument that you could, but it would be really bad brokerage practice, I think. Even 6 months ago, 3 weeks ago potentially, I think a good place to use as your benchmark in terms of reviving a contract is the earnest money still on deposit with the earnest money holder? If you've released earnest money and everything else, then do a new contract, right? Don't rely on a revival document. It's just there's too many pitfalls that could potentially arise. This is really meant to be used in those sort of intervening several, maybe day, 2, 3 days, 4 days after a contract dies. The parties are still sort of actively negotiating, trying to put it back together. They're both wanting to use that document to revive the contract. That's appropriate. If you've released earnest money, I think that's a good benchmark to say we're just going to do a new contract. So that's when I would say not to use it is if the earnest money's already been released back to the buyer because the contract terminated. So also I want to just point out that this is not meant to make it easier for you all to let contracts fail or to die or to terminate or to allow passive termination. That's never a best practice, and the parties need to understand that the only way that you're going to revive something that has actually died is if you have mutual agreement. In other words, that revival document obviously needs to be signed by both the buyer and the seller, and neither party would be under any obligation to sign that revival document a day later, 2 days later, 3 days later. So from a brokerage practice standpoint, please don't take the availability of this agreement to revive a contract as an opportunity to allow contracts to fail, because I think you're setting everybody up for failure. The best practice, of course, if you're bumping up against a resolution deadline and the parties can't come to terms, do an amend extend before that resolution deadline comes and give yourself a day or 2 or 3 or whatever is appropriate breathing time to appropriately dress it before allowing the contract to terminate passively or otherwise. So keep that in mind as well as you're using that document. But I do think it's a nice fills a nice vacancy that I felt like our Formstead had previously. So anyhow, questions on that or anything else, as always, you can call the Car Legal Hotline. Always love to hear from you. Take care, and we will see you on the next edition of Legal Bites.